paperwork, but I just had my right to fill it out.
If you did it, I'll take it.
Okay.
Thank you.
Cause he wants to make sure at the conclusion of this, he gets released, so I was like.
Got it.
And then,
Make it official.
just say, you know, you can do it every way, but disorderly is, or torturous manner such that the victim is placed in fear of
Is your case ready to go?
a small injury to their
They were gonna
life
have a
limb or
discussion amongst themselves before they came.
Oh, the two prosecutors.
This next.
Okay,
part,
all right.
Judge. Thank you.
Yeah, I'm just standing between tables.
the safety of their life limb or health. That's the language. Is that her right there?
Just thinking about where microphones are and all that.
I'll come closer. And Karen is not in here.
No, she's virtual, which is why I just need folks near microphones. All right, so you're Mr. Ross?
Yes, sir.
Good morning, Mr. Ross. Ms. Johnson, you're seated in the back there, is that right?
Yes.
All right, good morning. And that means you're Mr. Wright.
Yes, sir.
Okay, good morning, everyone. I'm Judge McBurney. Some of us have met before, some of us may not have met. But I have been told by Ms. Cabrera, who is Mr. Ross's lawyer, by Mr. Francis, who is your lawyer, Ms. Johnson, I'm gonna talk about that in a minute, and then by Ms. Vereen, who is your lawyer, Mr. Wright, that the three of you are prepared to enter a plea in your case. Is that correct, Mr. Ross?
Yes, sir.
Is that correct, Ms. Johnson?
Yes, sir.
And is that correct, Mr. Wright?
Yes, sir.
All right. Well, I'm gonna get on the record then, so we can make a record of all this. This is 24 SC 004077. And the first thing I want to do is start with Ms. Johnson. Your lawyer is Mr. Francis. He is a close colleague of Ms. Cabrera, and he explained to me, because he's got to be in another courtroom right now, that you are comfortable having Ms. Cabrera answer any questions you might have during the conversation we're going to have as a group. Is that correct? Okay, so you're comfortable moving forward just with this conversation, having Ms. Cabrera be your lawyer as well. Okay, and Mr. Ross, you have no concern with that?
No, sir.
Great, all right. Then here's how this is gonna work. In a moment, Ms. Dilligard, who's seated up here in front of you all, is gonna swear you in, and she's gonna ask you a bunch of questions. She'll state each question once, like state your name, and then she'll say, Mr. Ross, Ms. Johnson, and Mr. Wright. So you're each gonna be answering the same questions, but that way we can handle this all at once. It'll go faster for you, and you'll know the outcome much sooner. Mr. Ross, do you have any questions about the process?
No, sir.
Okay. Ms. Johnson, any questions about the process? Mr. Wright?
No, sir.
If at any point someone says something that doesn't make sense, or you can't hear, or you've got a question about what's going on, will you please let me know, Mr. Ross?
Yes, sir.
Ms. Johnson?
Yes.
Mr. Wright?
Yes, sir.
That's what we're gonna do. When you're ready, Ms. Dilligard.
Can you all please raise your right hand to the best of your ability? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Yes, ma'am.
Yes.
Please state your true, correct, and legal name, Mr. Wright.
You all can put your hands down. All right. And we're gonna go Ross, Johnson, Wright, if that's okay.
Please state your true and correct legal name. Start with Ross.
Michael Ronaldo Ross.
Johnson
Cynthia Johnson.
and Wright.
Emily Daniel Wright.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol, Mr. Ross?
No, ma'am.
Ms. Johnson?
No, ma'am.
Mr. Wright?
No, ma'am.
How old are you, Mr. Ross?
21 years old.
Johnson?
58.
Mr. Wright?
51.
How far have you gone in school?
All the way to 12th grade.
Say that again?
All the way to 12th grade.
You graduated high school?
Yes, sir.
7th.
8th.
Is English your dominant language,
Yes, ma'am.
Ms. Johnson?
I didn't hear what you said.
Is English your primary language?
Yeah, yes.
Do you understand that you have been charged with the following offenses? Count 1, aggravated assault, and count 2, reckless conduct, Mr. Ross?
Yes, ma'am.
Ms. Johnson?
Yes, ma'am.
Mr. Wright?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form with your attorney?
Oh, hold on one second. You mind closing that? They're having like an assembly out there.
Please don't rattle the chains.
Oh, all right. Okay.
Have you had the opportunity to review the waiver of rights form with your attorney, Mr.
Yeah.
Ross?
Yes, ma'am.
Johnson?
Yes, ma'am.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances related to these charges?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Would you like any more time to discuss this case with your lawyer?
No, ma'am.
No, ma'am.
No, ma'am.
Are you satisfied with your lawyer services?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Counsel, do you waive a formal reading of the indictment for purposes of this plea?
So waived for Mr. Ross and so waived for Ms. Johnson.
Same announcement, so wait for Mr. Wright.
And do you both counsel waive all and any defects in the indictment for purposes of the plea?
Also waived for Mr. Ross and Ms. Johnson.
Also wait for Mr. Wright.
Do you remember being arrested for these charges, Mr. Ross?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to? For the aggravated assault, it's 1 to 20, and for the reckless conduct, it's 12 months.
Yes.
No, ma'am.
Can you repeat the question?
Has their attorney advised them of the minimum?
Oh, right,
and
and that,
maximum?
okay, I'll advise you all. I just want to make sure you understand, count 1, aggravated assault, the sentencing range is 1 year to 20 years. And the sentencing range for reckless conduct, which is a misdemeanor, is 1 day to 12 months. So 1 to 20 years for aggravated assault, 1 day to 12 months for reckless conduct. Do you understand that, Mr. Ross?
Yes, sir.
Okay, Ms. Johnson
Yes.
and Mr. Wright.
Yes, sir.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, for defendant Ross and for defendant Johnson, the recommendation is 18 months, 18 to serve 6 months.
18 months to serve 6 months.
Yes, Judge.
Are the aggravated assaults being reduced to a misdemeanor?
Yes, my
Okay.
apologies. They're being reduced to disorderly conduct pursuant to OCGA 161139.
And that's Ross and Johnson.
Correct.
Okay,
And that is also with 100 hours of community service.
okay,
And for defendant Wright, the recommendation is 8 years to do 6 months. Balance probated with 150 hours of community service is what the state is recommending.
okay.
Do you understand that, Mr. Ross?
Yes, ma'am.
Ms. Johnson and Mr. Wright?
Yes, ma'am.
You understand that the court is not required to accept the state's recommended sentence? Mr. Ross?
Yes, ma'am.
Ms. Johnson?
Yes, ma'am.
Mr. Wright?
Yes, ma'am.
You understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Yes, ma'am.
Yes, ma'am.
Do you understand that, do you understand that the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
No, ma'am.
No, ma'am.
Judge, Mr. Wright currently has 2 VOP warrants for 2 Fulton County cases.
Okay,
They're pending.
pending as in they haven't been signed yet?
Yes, Your Honor, they haven't been signed, but it is for this arrest,
Okay,
and, failing to report and, failing to pay restitution.
okay. Do you have those case numbers?
Oh, yes, Your Honor.
The first one is 22 SC 182467,
Okay,
and the second one is 23 SC 187964.
okay. Thank you. Mr. Wright, we're gonna talk about it. Don't panic. But it's good to know that that's out there. All right, thank you for flagging that. Okay, back to you, Ms. Dilligard.
Do you understand that if you are currently on probation or parole, your probation and parole may be revoked based on your entering of a guilty plea today?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand if you're on probation, you must follow all the special, oh, I was only one response.
Ma'am.
Can I get responses from the other 2 defendants, please?
Yeah, we had a pause. Mr. Wright was asking his lawyer a question, so let's rewind. And if you'll ask that same question again, please.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Make sure you guys speak up.
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Do you understand that if you fail to follow any of the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
US citizen?
Yes, ma'am.
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am. My bad. I'm sorry.
All right.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
No, ma'am.
No, ma'am.
Is it your decision to enter a guilty plea because you're in fact guilty?
You want to talk with Ms. Cabrera for a second?
Yes to the conduct, but not to the,
No, just a second.
oh, yes, sorry about that.
That's okay.
Ms. Johnson?
I'm feeling the same way. To my reduced charges, ma'am.
Okay, Mr. Wright.
And Your Honor, I would like to seek probation as well before,
You'd like to pardon me?
I like to seek probation before, the plea concludes.
You'd like to speak with probation?
Probation, yes, but I wasn't aware of the two BOP warrants in this jurisdiction, so.
Okay, well, it doesn't sound like they're signed yet, so I don't know that there's anything technically holding him, but I'm gonna look up those cases.
Okay, so my conclusion of this plea.
Yeah.
More than likely.
We'll talk about it. Okay, but the question is now on the table, Mr. Wright, are you pleading guilty to these charges?
Yes, sir.
Okay, thank you.
Okay, Mr. Ross, how do you plead to the charges of aggravated assault? Oh, or no, you're pleading guilty to disorderly conduct and reckless conduct.
Yes, ma'am.
How do you plead in regards to that manner in indictment number 24 SC 004-077?
Guilty.
Speak up.
Guilty.
And Ms. Johnson, how do you plead to the charges of disorderly conduct and reckless conduct in indictment number 24 SC 004-077?
Guilty.
And Mr. Wright, how do you plead to the charges of aggravated assault and reckless conduct in indictment number 24 SC 004-077?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Yes.
Hold on, let's do two things. One, gotta make sure we go in order, but I want the record to reflect, since Ms. Rivers couldn't see this happen, that Mr. Francis has returned, so that while Ms. Cabrera has been acting with Ms. Johnson's permission and Mr. Francis's knowledge as Ms. Johnson's counsel, her actual appointed counsel is back in court and will resume those responsibilities. So the question was, do you understand, three defendants, that you have only a limited right to appeal your conviction if you enter a guilty plea? Mr. Ross,
Yes, sir.
Ms. Johnson,
Yes, sir.
and Mr. Wright.
Yes, sir.
Okay,
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, Mr. Ross?
Yes, ma'am.
Johnson?
Yes, ma'am.
Right.
Yes, sir. I mean, yes, ma'am. I'm sorry.
didn't mean to switch up on you. It'll be ma'am from here on out.
Do you understand that a felony charge, you only have 4 years from today to file a habeas corpus petition, Mr. Ross?
Yes, ma'am.
Ms. Johnson?
Yes, ma'am.
Right.
Yes, ma'am.
In their case, it's
Oh.
gonna be a year, because it's a misdemeanor.
Right,
Yes.
Yeah.
So I want to make sure, I'll just state that again. Do you understand that for the misdemeanor charges, you only have 12 months from today to file a habeas corpus?
Yes, ma'am.
And Ms. Johnson?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state would be proving that on June 14th of 2024, APD was dispatched to 25 Peachtree Street Southeast in reference to a person stabbed. Officers were met by the victim, which is Mr. Reginald Walls. He was stabbed by the defendant, Mr. Wright. Johnson stated to officers that Walls had stolen her Bluetooth speaker 2 days ago and that she was attempting to retrieve her property along with Mr. Ross and Mr. Wright. They approached the victim. They took a knife from him. Wright then lunges at the victim and strikes him with that knife. As Walls is being stabbed, he continues to hold on to his backpack during the attack and refuses to release it. He falls to the ground. He's struck in his arm, his hand, and while he's on the ground, the defendants appear to throw a water jug at him. Officers were able to locate surveillance, but we were not able to retrieve that from APD, unfortunately. The reason for the reduction in regards to Mr. Ross and Ms. Johnson is because they did not have the knife. They did not stab the victim, unlike defendant Mr. Wright. And all of this did occur in Fulton County, Georgia.
okay. Any success in tracking down Mr. Walls?
We've tried multiple, let me make sure this is the right one. Actually, we did try to contact the victim, but my investigator was actually made aware yesterday that the victim is actually deceased, and so we've requested a death certificate, and we're pending that at this moment.
Okay, got it. Thank you. Let me hear from Ms. Jackson. Any criminal history information on Mr. Ross?
Mr. Ross have 2 cycles. The last arrest was September the 11th, 2024 with the city of Atlanta for 2 counts of theft by receiving stolen property. There was no disposition for that arrest. There are no convictions.
Thank you. And for Ms. Johnson?
She has 4 cycles. The last arrest was July the 2nd, 2018 out of South Carolina for drinking alcohol in a public place. There was a non-conviction for her. That date was August the 1st, 2018.
And finally, Mr. Wright.
Mr. Wright has 78 cycles. The last arrest was March the 21st, 2023 in Fulton County for unlawful to knowingly remove / destroy. There's no destroy, circumvent operation. So felony, there was no disposition for it. And also he has a charge of a failure to appear. The underlying charge was not listed. He does appear to be on probation for felony obstruction. That case number is 23 SC 187964. That disposition date was August the 23rd, 2023, and the term is for 4 years. He does have prior felony convictions. One in 2011 out of Gwinnett County for forgery in the 1st degree. One in 2009 out of Gwinnett County for forgery in the 1st degree. One in 2003 for aggravated assault and robbery. One in 2001 for possession of marijuana with the intent to distribute. One in 1997 out of DeKalb County for forgery in the 1st degree. And he does have prior misdemeanor convictions. One in 2022 out of DeKalb County for theft by taking and obstruction of an officer. One in 2019 out of Shamley, Georgia for theft by shoplifting. He received a nolo contendere sentence in 2019 for theft by shoplifting. And there was a conviction in 2019 out of Dunwoody, Georgia for theft by shoplifting. There's one in 2014 out of Harris County, Georgia for simple battery. There's one in 2000 for battery, family violence. Nothing in addition, Your Honor.
Thank you. Appreciate it. Okay, let's start with Mr. Ross. Ms. Cabrera, I have found that he has another open case. So what we're doing today is resolving this one. I think he has a bond on the other case. It was
He
with,
does, he just hasn't, his mother hasn't paid it yet.
right, because he's stuck on this,
Right.
but we'll be back together at some point. I don't know, are you his lawyer on the other
I
case?
haven't got it. Doesn't mean it won't happen,
Okay.
just hasn't yet.
It is a,
What's the number on it?
I'm gonna pull it up in just a second. It is 24 SC 005867. And someone named Aaron Jenkins is the name listed, but that may have been from Judge Schwall's courtroom. I don't know that person. Did you hire someone in that case, Mr. Ross? No, it's the theft by receiving that we heard about from
So it got transferred from,
Judge Schwall.
okay. She said the arrest was in city of Atlanta, or was it a city of Atlanta case?
We look.
I got the impression it was a city of Atlanta case, because as far as he knows, it's a misdemeanor.
It's APD, and it may have been upgraded because it is burglary of the dwelling house of Ms. Smith, and then theft by receiving a Toyota Sienna and some financial transaction card stuff. But there are two co-defendants. There's a Mr. Martin and a Ms. Bernard. So it's a three-person case again. Anyway, it's with me now. We're not resolving it today. I just didn't want Mr. Ross to be surprised, like, wait, why am I back in court? If he's got bond, then, or if he can post that bond, that won't be.
You said it was
anything.
something as low as like $1,000?
There was a consent bond entered in October. It is $1,000. It was before it was indicted. So I don't know how that'll play out if he tries to post it because the indictment has new charges.
Okay, well, I guess as soon as he can be on the calendar before
We'll work
Your
through it.
Honor, then we'll deal with that.
Okay.
I'm pretty sure it'll come my way, it just hasn't yet.
It's on plea and arraignment in just a few weeks.
What's the date on that?
The 27th of February, so a
Okay.
little more than a few weeks.
Okay.
Um,
Thank you, Judge.
Yep, and we'll learn who the lawyers are. Okay. Mr. Ross, do you have any questions about anything we talked about, other than your new case? I don't want you to worry about the new case. This case, no questions?
No, sir.
Okay. Do you have a place to stay when you get out?
Yes.
And where is that? I don't need street address, but is it with family or friends?
Family.
Okay, all right. Ms. Johnson, do you have any questions about anything we talked about?
No, sir.
All right, did you used to be in South Carolina?
Yes.
Okay, what brought you to Georgia?
I used to live in Georgia, then I moved to South Carolina, then I came back.
Now you're back. Okay, do you have a place to stay when you get out? No, okay. All right, and Mr. Wright, any questions about what we talked about?
I just want to know about the probation.
So I looked up one of the cases, the one that Ms. Jackson mentioned, the 23 SC case. That was a case in front of Judge Dunaway, and you were sentenced to RSAT through Department of Community Supervision. Did you go do RSAT?
They didn't send me the RSAT. They let me go from jail. They let me go from here and told me to go to report to probation. And I was reporting to probation before I caught this case. I was going to probation over there up in right there by the driver license place.
Yeah, Memorial. It's not far from here.
Yes, sir.
Okay.
And
All right.
I was paying my money. So,
Okay.
you know, only way I caught there is this charge here. But
Well, and that would be, I think, what the issue is with probation in those other cases. Do you have any information about RSAT happening, not happening?
they didn't come get me.
Give me
They,
one moment.
Okay, you can look that up.
Let you know about
Okay.
and they let me go from here.
It's not on you. I mean, the way I understood Judge Dunaway's sentence, you were supposed to stay in custody until you went to RSAT, but something could have changed.
They let me go.
Well, that would be something that changed. Okay, I don't think you escaped. All right.
Yeah, I don't see that he completed it and or entered.
Okay, well, if he never entered it, then he couldn't complete it. All right, we'll work through that on another day. For the three of you, I find there's a factual basis for each of your pleas. It sounds like you had different connections to what happened with Mr. Walls. And I find that for each of you, your pleas are knowing and voluntary. Knowing means you've understood what we talked about. And if you didn't, you asked, and you guys asked good questions. Voluntary just means no one's forcing you to enter these pleas. Mr. Ross, is it okay if someone in my office signs your name on the indictment indicating your plea? There's going to be an electronic signature. It'll just say Mr. Ross pled guilty.
Yes, sir.
That's okay. Ms. Johnson, can we sign your name as well?
Yes, sir.
And Mr. Wright, okay if we electronically put your name on there?
Yes, sir.
Ms. Cabrera,
Yes, Your Honor.
Mr. Francis,
Yes, sir.
Ms. Vereen,
That is, yes, sir, that's fine.
okay, and Ms. Dilligard.
Yes, Judge.
We'll take care of that. Mr. Ross, I'm gonna follow the recommendation here, although, a little time out, the math I've done, Mr. Ross only did about,
4 months.
if you add the two cases together, but it's 121 days on the other case that's open. It's 29 days on this one.
He knows he's not going anywhere right this.
Okay, as long as he knows
Yeah, he
that.
knows that, and I gave Ms. Delgard my card so we can try to figure out if it's possible to reach a resolution before the arraignment calendar.
Excellent. Highly likely. Yes, ma'am.
And Your Honor, just to touch back on that RSAT, at the time, the defendant actually had pending charges, and so he wasn't able
Able to go.
then-
Okay. Understood. All right. So then I'll follow the recommendation. I just want to make sure, because Ms. Johnson has spent a whole lot more time in custody, and so it's just a slightly different outcome, same sentence. Mr. Ross, on count one, I am sentencing you to 6 months to serve. That's the disorderly conduct, followed by 12 months probation on count two. That's the reckless conduct, for a total sentence of exactly what your lawyer said you'd get. 18 months to serve 6 months with the balance probated. And you will get credit. I don't know that you're going to get credit for all the time you've been in, because you've actually been in on 2 different cases. But one of the things Ms. Cabrera is trying to do is, and work out that other case as well, then you can mush it all together. But for this case, you'll certainly get credit for the month you were in before you bonded out and then got picked up on those other charges. When you do get out, you will be on probation for 12 months. As I said, I will waive the supervision fees for the first 3 months while you get on your feet, hopefully get some work going, and you will need to do 100 hours of community service. Any questions about any of that?
No, sir, I'm willing to follow every rule and commandment.
Okay, I don't issue commandments, but I did issue a sentence. All right, Ms. Johnson.
Yes.
I am going to sentence you to 6 months to serve on count one, which has been reduced to disorderly conduct, followed by 12 months probation on count two, that's the reckless conduct, so 18 months to serve 6. You'll get credit for the 209 days you've been in custody. That's more than 6 months, so you ought to get out tomorrow. Tomorrow's gonna be a strange day in Atlanta, so if you don't get released, it's not because anyone forgot about you, it's because there's snow on the ground and that kind of shuts stuff down. If you're still in jail next week, you call Mr. Francis, he'll bug me, and we'll figure out what the holdup is, okay? Excellent, good, he'll do that. You will also have 100 hours of community service. You need to plug in with probation. I'm gonna waive your supervision fees for the first 6 months while you figure out a stable place to be, okay? All right, Mr. Wright, count one, I am sentencing you to 8 years to serve 6 months with the balance on probation. Count two is 6 months to serve, that'll run concurrently at the same time. So it's a total of 8 years to serve 6 months, balance probated, and then you'll be on probation. I'm gonna waive your supervision fees for the first 3 months when you do get out. And then you're gonna need to do, I know the request was 150, but I'm gonna have it at 100 hours community service as well, when you are out. I'm gonna hold off on signing your final disposition because we need to sort out this probation piece. We don't need to do that right this moment. I wanna let some other people go, but I need to make sure probation has a chance to do what they need to do in connection with probation. And it may be that we talk about that as a threesome as well, okay? Do you, Mr. Ross, have questions about your situation?
Other than that, well, I'll be doing my 6 months after starting today.
You receive credit for time served, so your 6 months has already started. The question is when that's gonna actually resolve, and we're gonna work on trying to resolve your other case. And
But
then-
you get credit from today, you get credit for the 29 days for sure,
Yeah.
and your clock is running.
Okay.
So if I don't see you again, I'm making this up, for 3 weeks, you'll have done 3 more weeks on this sentence. And then we'll be figuring out, what are we doing with this case with the burglary and the stolen Sienna? Okay. All right, Ms. Johnson, any questions? Okay, Mr. Wright, other than about your probation, any questions?
No, sir.
All right, then what I'm gonna have you do is go back there, all 3 defendants go back there. Ms. Vereen, if you'll just sit tight, we're gonna sort out, we don't need to give reporting instructions to Ross or Johnson, and we're gonna hold off on Mr. Wright, because we need to work through a little bit of probation, okay?
Yes, sir.
We'll bring you back out here,
Thank you.
all right?
Yeah,
Yes?
I'm sorry, can you repeat Mr.
Yeah,
Ross?
I'll give you my mama number.
Okay.
Yeah, just a sec.
389
Mhm.
0171.
What's her name?
Miss Landon. LIN DL.
Okay, what I'll do is I'll get an email address from her.
Okay.
Because once we get all of this worked out, you're gonna be able, you're gonna have to report to misdemeanor probation, so I gotta send you
Okay.
information for that.
Got
Okay.
it. And this is a routine?
Yeah, but she was born to have a little heart murmur, so they're just making sure that it was.
Good,
Yep.
okay, good luck. I'm glad it wasn't tomorrow, because it's not gonna happen tomorrow.
Yeah.
Do you need to head out to the doctor now?
Thanks for your accommodation, Judge.
You bet.
You're doing stuff upstairs.
Okay. I'm here all day.
I heard, we did 8 or 9.